And now what about problem analysis? What are some of the kinds of problems we might want to be thinking about so we can identify the risks that we'll then manage? Well, what about product failures? So imagine that you are in practice and you recommend a fertilizer for someone who's seeking fertilizer, much like the case that Tony mentioned. And that fertilizer turns out not to be very good, and the yield is not very good, and someone then has a claim. What about environmental contamination? Imagine you're at a job site or a work site doing a site assessment, and you back into a barrel of diesel fuel, and it spills, and there happens to be a creek, and it spills into the creek. That's going to result in potential liability. What about property damage or personal injury? What if you're driving? You're driving to work. You're driving to a work site. It's late, you're tired, you cross the center line, you kill someone. That can result in liability. Even though it doesn't really seem like it's that related to practice, if it happens in the course of your work, it is practice. What about substandard professional advice? Imagine you're working in the reclamation or remediation field. Imagine you've been asked to give some advice about something, but imagine you decide that you're going to do that and you're not fully competent to give that advice. How are you then going to defend the advice that you gave if it turns out to be wrong? That will give rise to liability. What about a breach of privacy? Imagine something as simple as you're in charge of, your consultancy, you're in charge of keeping track of people's phone numbers and addresses in your computer. And you leave that computer in your car, and the car gets stolen. That can give rise to liability under the Information and Privacy Commissioner's Office. Right? There was a case a couple of years ago, a little bit different. Somebody was accessing private information in a healthcare setting, $10,000 fine for accessing it without authority. So that's risk identification. And those are a couple of different ways you can identify risks. What about the assessment of vulnerability to those risks? So once you've identified the sources, you want to assess the vulnerability by asking questions. Are we in an area that we are fully qualified and capable to practice in? If not, we are vulnerable. Are we, is there a gap in our process leaving us vulnerable? Is there somewhere we can tighten up that gap? Right? Are we able to identify that gap ourselves, or do we need someone to help us identify those gaps? That's vulnerability analysis. What about risk determination? Remember, we're not going to get into risk determination in any detail because you don't want to listen to me try to talk about probabilities or statistics or anything. But you need to think about this because you can come up with a very long list of potential risks. And if you were to try to manage all of them, you would not be successful. Right? You cannot manage all of the risks. You need to decide what are the significant risks, and that's what risk determination is all about. So now that we've identified them, what about the strategies we can use to manage them? So there's 4 real categories of strategies. One is avoiding risks, meaning you eliminate them. That sounds pretty good, doesn't it? Let's just eliminate all the risks. The problem with eliminating the risks is that you can't eliminate all the risks. There are risks inherent in everything we do, in our personal lives and in our professional lives. The only way to really eliminate all the risks is to do absolutely nothing. And if you were to do absolutely nothing, you're foregoing all the potential upside to running your businesses and running your practices. So you cannot avoid all these risks. When I was thinking about this, it occurred to me that one thing you can do is you can do strategic planning. You should be doing strategic planning. I realize it's a buzzword. Everybody talks about it. It seems like kind of a lot of work. It doesn't have to be a lot of work. Right? You can do it in a very sophisticated, complicated, time-consuming way, just like risk management. Or you can do it in a simple, straightforward, sit down and think about it kind of way. Strategic planning, when you break it down, is really about what are we doing, what do we want to be doing, and moving towards what you want to be doing. And it occurred to me as I was preparing these remarks that if you strategically plan what you want to be doing, you're going to identify areas where you're doing stuff, you're out there doing it because I don't know why you're doing it. It just sort of developed that way. But you could stop doing that. And if you stop doing things you're not sure there's a suitable reward for, you're going to remove all the risks that go along with that activity, and you're going to focus your efforts on the activities you do want to be doing where the risks are worth it because the rewards are better. You might also, through strategic planning, identify some niche area where nobody else is really doing it. and maybe you can focus your efforts there, and maybe that is worth the risks that go along with it. So strategic planning, really good risk management strategy. That's avoidance. What about reduction? Risk reduction, this is where most of the effort will go. Okay? So reduction means to mitigate the risks that are unavoidable and to optimize that risk-reward balance. So for me, in my practice, I know that when I'm asked to do something, the first question I ask myself is, okay, is this professional regulation law or is this labor and employment law? Because if it's one of those things, then yeah, okay, I'm competent to do that. I can do it efficiently, cost-effectively, and my client will get the result that they want, or at least the advice that they want. Whether it's the result they want, I don't know. David will tell you. If, though, I'm asked to do something that's not professional regulation law or labor and employment law, I have to think about that a little more. I have to ask myself, am I competent to do this? Do I have to teach myself how to do this? Is my client prepared to pay me to learn how to do this? Or is there somebody else in my organization or outside my organization who is competent to do this and who can do it more efficiently and can get the better outcome? Because if it's the latter, then I shouldn't be doing this. Right? That is a risk management strategy. If you do things you're not competent to do, that's a huge risk. You might get paid, maybe no one will realize, but later on, it's entirely possible someone is going to realize, and you're going to get a complaint, or you're going to get a charge under offense, criminal code, whatever. You don't want to do that. Not worth it in the end. So that's risk reduction. What about risk sharing? Sometimes risk sharing is referred to as risk transfer, and the big technique under risk transfer or risk sharing is insurance, right? You're sharing that risk by having somebody else take part of the burden, by having the insurance company, the insurance pool, which is all underwritten by insurance companies, and then even more insurance companies under that, share that risk around. So why is it not a risk avoidance technique or a risk transfer technique? It's because no matter what, you can share it around, but you can never get rid of it altogether. Right? You'll always bear some portion of that risk. You're going to pay premiums for that insurance, so you're paying for it. You're going to pay deductibles sometimes for that insurance, so you're paying for it. And there is always the risk that you will get into a dispute with the insurer about coverage. They don't cover everything, and there are exclusions and endorsements, we'll talk about that exclude and remove things from the insurance. You might think you're covered, they might disagree, and then the risk still falls on you. So that's risk sharing. And lastly, risk retention. Risk retention is just what are we still on the hook for after everything else we've done to manage these risks. So some people refer to risk retention as self-insurance. You're really just taking that risk yourself, you're budgeting for it, you're planning for it, and you're saying if that risk materializes, I'm personally on the hook for that portion of it. So now what are these practical strategies that I was talking about? What strategies can we come up with to implement? So I've given this talk before, and originally the arrow was on the other side of the slide pointing this way, but my wife made me change that. So as I was thinking about giving this talk, I was thinking about what are some practical things I can give to you that you might be able to take away and use right away. So in my years of practice, I've come up with a few things, very simple things. You'll probably think they're very simple. You'll probably be doing some of them that you can take and you can use. And even if you can't take these and you're already using them, it might spur on other ideas that you'll come up with for your own practices and your own businesses. So here they are. There's 7. I'm still working on the list. Ultimately, I'd like to get to 10. So for now, we have 7. So the first one is, well, risk management. We should do that, right? We should do that risk management exercise. Number 2, continuing competency. I sort of alluded to that when I was talking about risk reduction. It's important to make sure you remain competent in your areas of practice, because if you do that and you stay within that area of practice, you'll have the best chance of reducing and minimizing those risks. The third is having good working papers and reports. Incredibly important for defending your practice if there ever is a complaint or a lawsuit or a charge. The fourth is document retention. Probably goes without saying document retention is important. How can you demonstrate someone did their due diligence and had good working papers and reports if you can't find the good working papers and reports? 5th, good written contracts. Those are always important to have. 6, managing expectations. I'll tell you what I mean by that in a few minutes. And then lastly, of course, insurance. Do risk management. That's number 1. Do that 4-step analysis. Identify the risks, figure out the vulnerabilities, determine the risks, whether you do a complicated statistical type of a thing to figure out how likely these risks are to materialize, or you just use your best guess. Do that part of the analysis. Figure out which risks are we actually going to have to manage, which ones do we have to leave aside because they're too remote to expend resources to manage. Identify what strategies you're going to use to manage those risks, and then prioritize how you're going to implement those strategies. So continuing competency, we alluded to this before. Of course, you all know that the AIA has a continuing competency program. You're required to obtain a certain number of credits every year. That's why you're here. You can do it by coming to sessions like this. You can do it by lecturing. You can do it by teaching. You can do it by participating in governance, research, etc. So what does that program do for you, right? Other than, one more thing you have to do every year when it comes to renewal time is to certify that you've done all this stuff. Well, what it really is a means to make sure that you remain competent in the areas of practice that you're in. It's also an effective means of managing risk. So it makes sure that you have all the required knowledge for what you're doing, and it makes sure that if you decide to branch out and do something a little bit different or a lot different than what you're doing, you know what you don't know before you start. Right? Because we don't know what we don't know. And before you start doing something in a different area of practice, you want to make sure that you are competent to practice in that area, that you do have the requisite knowledge, and you do have the requisite experience. And the Continuing Competence Program is one way to make sure of that. Lastly, on continuing competence, there is an aspect of professional risk we haven't mentioned yet, and that is the enforcement of those continuing competence requirements. Enforcement of those requirements will be done by practice review. So the Competence Committee at the AIA will review your annual applications for a practice permit when you renew your membership every year, and they will pick some and they will audit compliance with the Continuing Competence Program. And if you're found not to be compliant with the Continuing Competence Program, they will do one of a few different things. They might make recommendations for you. Go and finish the program now. That will be a relatively minor thing for them to recommend for you to do. They might impose a condition on you. You must go and do these things, or you will be suspended. Or, slightly more severe, you will be suspended until you go and do these things. Or you could be referred to the discipline process if you're really not compliant with the Continuing Competence Program. Okay, so that's continuing competence as a risk management strategy. Good working papers and reports is another really important risk management strategy. How do you defend your professional practice? It's not enough to just meet the expected standard of professional practice. You have to be able to show that you did, right? Because you're going to be facing someone like me who's advancing some kind of allegation against you. I'm not an agrologist. I don't know. But if you can demonstrate to me what you did, it's a whole lot easier to show me that you did something appropriately. So it sounds very simple to say show your work, right? We think back to grade 3 math class, and that's what they told you to do, is show your work. That really is an important risk management strategy in professional practice. And even though it seems very obvious, it is not as obvious as you might think for some people. So, I was involved in a case a few years ago. This is a case where there was a professional engineer, and he was retained to assess the integrity of a concrete slab foundation in a building. It was a cold storage building. And that building was really old, and somebody had bought it and wanted to use it for a different purpose. And the different purpose was to drive these great big vacuum hydro trucks in and park them in there, store them in there. So his job was to go in, do some testing, issue a report that said whether or not the floor would hold up to these trucks. So he does that. He goes in, he takes core samples, he measures the compressive strength of the concrete sample. Then he takes the sample to a lab, gets the report back, and he writes his conclusion that the compressive strength of the concrete is 18 times higher than the expected load exerted by the tires on the truck. And then he writes a one-page report, and the report says the compressive strength is this, the expected load is that, therefore there's no problem. Now, I am not an engineer. Is anybody here an engineer? No engineers. Does anyone think that's good? Would I be telling the story if it was good? No. What do you think, just glancing at that, might be wrong with doing that?
Ground underneath.
Yeah, exactly. I'm not even an engineer. I knew that. It's a great big flat slab of concrete sitting on the ground and you put a huge weight on top of it. What do you think is going to happen? The concrete is going to bend. It flexes. Right? That you don't need to be an engineer to think about some of this stuff. Right? This is not a quote from his actual report that he used, but this is very similar, believe it or not, to the report that he actually used. So all he says is the purpose of generating the report, the results, and his conclusion. There was no working papers. He was up before a discipline tribunal of the regulatory body. He produced no working papers. He produced no notes. All he did was come and say, this is my report. The report actually said, I didn't do any other analysis. But at the hearing, surprise, surprise, he came and testified that he did do a whole lot of other analysis. He came and said, oh, I had a structural engineering friend, and he helped me do the analysis, and he had a computer model, and I put it through the computer model, and everything is fine. Now, what do you suppose the discipline tribunal said when they looked at his report that said I did no other analysis than that, and then he testified at the hearing that he did a whole lot of other analysis? They're lying, right? We think you're lying. And of course he was convicted, he was found guilty of unprofessional conduct, and he received a whole lot of sanctions. So this is a different report. Have a look at this report. This report still says the purpose of the engagement, it says the results, and it says the conclusion, but there's a whole lot of other things that are in it. This says the methods that were used. This says the literature that was reviewed to come up with the analysis. This states the reasoning, charts and graphs and things, that led to the conclusion. It includes limitations on the analysis. What can you use this analysis for? What can't you use this analysis for? Which report do you suppose would be easier to defend if this person was up on a charge of unprofessional conduct or any other kind of legal liability issue? That takes us to the due diligence defense. So the due diligence defense is this idea that you can defend your conduct by showing that you, on a balance of probabilities, took all reasonable steps to ensure that what you were doing was on side and to avoid committing an offense. And this is really useful because most regulatory offenses, like some of the criminal offenses and most of the Environmental Protection and Enhancement Act and similar statute offenses, are what are called strict liability offenses, which means they don't need to prove that the mens rea, the mental element of an offense that you might have heard about. All they need to show is that you did it and it was a breach of the statute. Never mind what you were thinking at the time. But if you can show that you did everything possible to avoid that problem, you have a much better chance of defending your own conduct. That works to a degree with professional regulatory liability as well. So all of that to say, if you can show your work and show your reasoning and show that you did everything you were supposed to do to come up with the conclusion that you did, we'll have a much easier time defending the conduct that you commit. Okay, now document retention. A lot of time and energy goes into developing document retention policies and organizations, and there is a very good reason for that. Because document retention is incredibly important when there is a charge or a lawsuit or a professional regulatory allegation. If you dispose of evidence after you know one of those things is going on, you can get in a lot of trouble. That's called spoliation of evidence. Don't do that. But even before you know about those things, ideally, you would be saving all of your working papers, all of your notes, all of your emails for various projects in an electronic document management system forever. Right? I know that sounds like a huge obligation, but remember, there is no statute of limitations on professional regulatory allegations. Someone can complain about you for something that you did the day you became a member of the organization, even if it's 30 years later. And you will have to respond to that. It would be a whole lot easier to respond to that if you can find the documents around that engagement. It may be possible for you to say, well, I destroyed records in the ordinary course of business in accordance with the document retention policy that we have in place, and it would be unfair to proceed against me now after all this time has passed. You might be able to do that, but it would be a lot easier if we had the emails and the documents and all that stuff. So, yes?
But if you're an employee, you don't necessarily always have those access to those.
That's very true. That's very true. So in those cases, if you work for an organization that has a document retention policy of some kind, and you're complying with it, you'll have an argument at least that, of course, you can't produce those documents because I didn't have control over it. I did everything in my power to retain those records, but they're gone. And so it would be unfair to proceed against me now. And that might be the best that you can do in that situation. Okay, that's document retention. Written contracts, also very important. So written contracts can be a little daunting to think about, but they don't need to be very complicated things. It's very good to spend a little bit of time and a little bit of money, if you're in a position to negotiate contracts, to have some legal advice, to prepare a template, and then to just use that same template as many times as you can to get the value out of it. So if you're in a small business or on your own, and you're in a position to say, I'm being engaged, I want you to use my retainer engagement, you can have some protection in there for yourself. Or if you're a business person, you're engaging other people that provide services to you, and you're in a position to demand those agreements, that's great. Realize you're not always in the position to negotiate those types of things. So if you can, do it. If you can't, suggest it to the people who can. What are the important things for those agreements to specify? Well, it's really important to specify who is going to do the work that we're talking about. What work are we going to do? If you don't specify what work we're going to do, then later on there might be a question about, weren't you going to do a whole lot more than that for the amount that we agreed to pay you? We want to avoid disagreements and misunderstandings like that, because those can lead to complaints and liability. Another important thing to put in there is who's going to pay for the work and how much are they going to pay. That's incredibly important to have in there, because that's obviously a fruitful ground for disagreements. When will the work be done? Deadlines are important. Who do I report to? That would be useful to specify in there. And then ideally it would also specify that you are entitled to use your professional judgment and your own expertise. And you can disagree with your employer or your client or whatever. And that way, if there's ever a dispute about whether you were insubordinate because you didn't want to do something they told you to do, you can say, no, I was not insubordinate because I'm entitled to use my own expertise and my own judgment and to disagree. Managing expectations. There is, in most of the provinces, what are called apologies legislation. So Alberta has it inside the Evidence Act. Some statutes in other provinces are actually called the Apologies Act. And the idea behind this is that for a long time, lawyers would tell their clients, you can't apologize for things that don't go well, because if you apologize, they'll use that apology against you in court to prove that you're liable for something. And so people didn't want to apologize, even though apologizing would have diffused disagreements, would have avoided complaints, would have avoided lawsuits, would have avoided a whole bunch of problems. So they put these things in the statutes. And now, in Alberta, for example, you can express that you are sorry something didn't go well, and that expression of regret cannot be used against you to prove your guilt in court. There's still a question about whether it could be used in a professional regulatory context, but arguably by analogy, it should not. So, you can apologize. But managing expectations, of course, is about a little bit more than just apologizing. It's about having a good idea at the outset about who's going to do what and when. It's about maintaining open lines of communication. It's about, if things are not going well, sitting down and talking it through right away. It's about not avoiding emails, not avoiding phone calls, not avoiding dealing with things before they get out of hand. Because if you can do that, you can avoid the disagreements that drive all of these liability problems. Because when they come down to it, a lot of them are about people and people not getting along. If people don't get along, they're likely to complain, they're likely to sue. This next slide is about the elements of an effective apology, and I included this. My wife sent me this thing from the Huffington Post a couple days ago, and the first thing I wondered was, what am I supposed to be apologizing for? I'm not sure. And the second thing I thought was, oh, I could use that in my talk. So when we talk about apologizing, it's not enough just to say, oh, you should apologize and beg for forgiveness. If you're going to use an apology effectively, why not think about what is an effective apology and how do I make sure that that's going to be effective in this risk management construct we're talking about. So what's an apology all about? Expressing regret, right? That's very important. But explaining what went wrong is more important. Even more important, acknowledging responsibility. Being the person to acknowledge responsibility is incredibly important, it turns out, in diffusing the issues in a dispute. Also incredibly important, the offer of repairing the problem. Declaration of repentance, not so important. Request for forgiveness, apparently not so important, at least according to the Huffington Post. But, when I was thinking about this, it occurred to me that's probably right. Because how many of you have been involved in a project where something has not gone well? Right? Of course I have. Right? Maybe a deadline was missed, maybe something was substandard and had to be redone. These kinds of things can create all kinds of disagreements, can drive complaints, lawsuits, etc. Now, how many of you have had someone come up to you after something hasn't gone well and said, oh, that wasn't my fault, but yeah, we'll fix it, right? Don't worry about it. That is infuriating, right? It doesn't do anything to diffuse the problem. But now imagine the situations you've been in where someone has come up to you and said, you know what, that didn't go well, I'm responsible for that. It was a team thing, but I'm part of that team and I take responsibility and I'm going to fix it so you don't have to worry about it. That is a lot more effective. A lot more effective in getting people back on side, avoiding that complaint to the AIA, avoiding that complaint to the police or the regulatory authorities, and keeping you out of trouble. And then lastly, insurance. We've talked a lot about insurance, so I only have a couple things to say about insurance. It's a risk-sharing measure. We talked about that. It's important, though, to not just buy the insurance and then forget about the insurance. You have to understand what the insurance is. And there are things in insurance policies that, although incredibly boring to read, you need to read. Okay? There's policy language. That's the main body of the insurance document. And these two are laughing because they know. There are exclusions, and there are endorsements. Reading the policy is important. We have lawyers in our office who do nothing but insurance law, and that is because it's very technical, some of the stuff that's in these documents. I am a lawyer. I'm not an insurance lawyer, but I can't read these things without looking stuff up and then trying to ask questions to figure out what they say. You should get some help to make sure you know what's in your insurance policy. And the best person to ask about that is your insurance broker, the person you're buying the insurance from, because they can tell you what's covered and what's not. You can tell them, I want coverage for this, this, and this, and they will tell you whether this policy will include it and or whether it won't. They're not going to like this either. The other thing that you need to do when you have a broker is you have the broker so that if something does go wrong, you have someone to look to if the policy turns out not to cover you. So you've got to understand the policy language, you've got to understand the exclusions. Exclusions take things that are in the policy and they take them out. So even if you read part of the policy and it says you're covered for all perils, for example, there might be an exclusion that says you're not covered for this peril. So you need to read both. Same thing with endorsements. Endorsements sound like they're adding things, but they can add things, they can also take them away. So you need to read all that. Lastly, the tips on insurance. Probably if you're in business, you need to have commercial general liability or CGL. You need to have errors and omissions or professional liability insurance, which is what Peter and Tony were talking about. If you're incorporated, you also want to have directors and officers liability, because remember, the directors and officers can be personally liable for things. And lastly, don't try and just understand these things on your own. Get an experienced insurance broker to talk through it with you and make sure you have the coverage that you want, because insurance is a very important risk management measure.